Hello everyone, welcome to Courts Today by Live Law, your go-to source for the latest and fastest legal updates. I'm your host Urvashi Chauhan, here to bring you daily developments, landmark judgments and significant rulings from the world of law. Let us begin with the headlines and a concise overview of the top stories, and then we will delve into the full details. In a significant ruling, the Supreme Court has held that storage of child pornography without deletion or reporting indicates intention to transmit and constitutes POCSO Act offence. Regarding the Tirupati Laddu controversy, various pleas have been filed in the Supreme Court seeking independent investigation. Saying that internet shutdown violates fundamental rights, the Jharkhand High Court has restrained the government from suspending internet on ground of conducting exams. The Delhi government has told the Supreme Court that remission pleas stalled due to ex-Chief Minister Arvind Kejriwal's incarceration can now be processed. The Bombay High Court has voiced concern over the accused being released on technical grounds, even in serious offences. The Delhi High Court has held that Flipkart's latching on feature cannot be used to sell counterfeit products or mislead gullible public. The Kerala High Court has closed anticipatory bail applications moved by actor Jay Surya accused of sexual harassment. National University of Juridical Sciences Kolkata alumni have written to CJI DY Chandrachud requesting convocation ceremony for 2021 to 2024 batches. The Supreme Court has delivered an important judgment today. One of its kind, the judgment spans to 200 pages. It has held that storage of child pornographic material without deleting or without reporting the same indicates an intention to transmit and is an offence under the POCSO Act. With this, the court set aside a previous judgment of the Madras High Court which had held that if such content is stored by a person without the intention to transmit it further, then it is no offence. The Madras High Court in the particular case had observed that the accused had only downloaded the material for private viewing. It was not published or transmitted. And it was argued that merely downloading and watching child pornography was not an offence under the IT Act. And to attract the offences under the POCSO Act, a child or children must have been used for pornography purposes. In the present case, the accused had watched pornography videos but had not used any children for pornographic purposes. So, according to the High Court, the act could only be construed as a moral decay on the part of the accused person. After this judgment, a coalition of NGOs named Just Rights for Children Alliance challenged the High Court's view, raising concerns over potential impact of such a ruling on child welfare. Now, observing that the High Court committed an egregious error in quashing the criminal proceedings, the bench comprising CJI DY Chandrachud and Justice J.B. Pardiwala has set aside the High Court's decision and has restored the criminal prosecution in this case. The court ruled that simply watching child pornography online without downloading it is also considered possession under Section 15 of the POCSO Act. Let me tell you, this section defines the offence of storing or possessing child pornographic material with the intention to transmit it. The court said that a person's intention to transmit can be gathered from their failure to delete or report the material. The judgment authored by Justice Pardiwala contains various guidelines and suggestions also regarding the enforcement of the POCSO Act. The Supreme Court has recommended that the Parliament amend the Act to replace the term child pornography with child sexual exploitative and abuse material. The court stressed that the term child pornography downplays the seriousness of the crime and the victim's trauma. Since pornography typically refers to consensual sexual activity between adults, using it for a severe offence against children is inappropriate. Significantly, the court also suggested the government to create awareness about the POCSO Act among children and implement sexual education programs. To read in detail, you can visit livelaw.in. You must be aware of the recent controversy regarding the alleged use of adulterated ghee in preparing laddus at Tirupati temple, which are offered as prasadam. A lab report alleged that animal fats, including beef tallow and fish oil, were used in preparation of the laddus during the tenure of the previous government. This revelation caused an uproar among devotees and political leaders, leading to demands for an investigation. Andhra Pradesh Chief Minister Chandrababu Naidu on Sunday also announced formation of a special investigation team to investigate the ghee procurement for Tirupati Laddu. Additionally, he ordered an audit of procurement process of raw materials for all temples in the state. In wake of this, a petition has been filed in the Supreme Court seeking an investigation by a committee headed by a retired Supreme Court judge or a retired High Court Chief Justice into the matter. The petitioner Suresh Khanderao Chawanke, the editor of Sudarshan News TV, has argued that the use of non-vegetarian ingredients in the prasadam violated fundamental rights of devotees under Articles 25 and 26 of the Constitution, which guarantees freedom of religion and the right of religious denominations to manage their own affairs in matters of religion. The petitioner submitted that the matter is of utmost importance to millions of devotees and required immediate attention from the highest court of the land to protect the sanctity of religious practices and restore faith in the temple administration. The petitioner has also sought an independent investigation by the CBI or any other independent central agency. Let me tell you, another PIL regarding the same issue has been filed by senior BJP leader Subramanian Swamy, seeking investigation by a court-monitored committee into the allegations. Besides praying for appointment of a committee, Swamy has sought direction for a detailed report from the authorities on the forensics of ghee sample used by the concerned lab, including its source. In a special hearing held yesterday, the Jharkhand High Court temporarily restrained the government from suspending internet services in the state on the grounds of conducting any examination. The Jharkhand government had decided to impose a blanket ban on internet services across the state to prevent unfair practices in the Jharkhand General Graduate Level Combined Competitive Examination, which were to be held at various examination centers on 21st and 22nd September. The bench of Justices Ananda Sen and Anubha Rawat Chaudhary held a hearing on Saturday 1st, where the State's Council assured that only a partial ban was in place. The court at that day had refused to grant interim relief to the petitioner, noting that it considered the balance of convenience between the parties. The court had explained that the internet was not completely disabled and only mobile internet was partially disabled for a limited time. However, after the court's order on 21st September, all internet services, including broadband, were completely suspended. So, a special sitting was held yesterday to hear the PIL challenging this. Additional Advocate General for the state told the court that some intelligence input was received at night, so the government decided to shut down the entire facility. The court deemed this action by the state as a form of judicial overreach against its order. The court observed that merely using terms such as public interest, adequate safety of students, and ensuring fair examination without proper factual evidence was insufficient to justify the complete shutdown of internet services across the entire state. It further said that shutting down of internet facility amounts to an infringement of fundamental rights guaranteed under Article 19 of the Constitution. In the next update, the Supreme Court bench of Justices Abhay S. Oak and Pankaj Mittal today heard a plea related to delay in deciding remission of a convict. The same had been delayed due to Aam Aadmi Party chief Arvind Kejriwal being in jail and unable to perform his official duties. The Supreme Court had directed the Delhi government to take a decision on granting permanent remission to the petitioner in this case, but as the Chief Minister needs to review the file before it can be forwarded to the Lieutenant Governor, it had remained pending. However, in wake of Atishi Marlena's appointment as the new Chief Minister of Delhi, the Delhi government has now told the Supreme Court that it would now be able to process remission pleas which are pending. The bench has directed that the remission plea of the accused in this case be decided within 3 weeks. In another important update, the Bombay High Court has today expressed anguish over the fact that in several serious offences, accused are released only on a technical ground that the investigating officer did not give them grounds of arrest in writing. The bench of Justices Bharati Dangre and Manjusha Deshpande was hearing a plea filed by Mihir Shah, the prime accused in the Worli hit and run case. Shah is the son of Maharashtra Chief Minister Eknath Shinde's close aide Rajesh Shah. He was arrested on 9th July, 2 days after he dragged a woman while driving his BMW car in the intoxicated condition in Mumbai's Worli area. He has challenged his arrest, stating that the same is illegal since the investigating officer did not give him the grounds of arrest in writing. His counsel advocates Rishi Bhuta and Niranjan Mundargi argued that the IO did not provide the grounds of arrest in written form and thus violated the rights under Article 21 and 22 of the Constitution. Countering the submission, Chief Public Prosecutor Hiten Vengaonkar pointed out that the IO had orally told them about the grounds of their arrest and also explained to them their legal rights. He further informed that the investigation team had strong evidence, including CCTV footage showing Shah in the driver's seat, with his driver Rajrishi Bidawat. Witnesses had also identified the two fleeing the scene after committing the crime. It was further stated that Shah, aware of his serious offence, he altered his appearance to avoid being recognized. The court has now directed the IO to responsibly make a statement on an affidavit spelling out as to the manner in which the ground was communicated and whether the panchas were present while arresting the two accused in this case. The bench noted that in several cases, the accused get relief only on this technical ground and they are released from the custody of the police, which somehow hampers the investigation. The judges expressed the need for balancing the issue, as not in every case, particularly in a serious offence, an accused can be released merely because the grounds of the arrest were not communicated to him or her. The Delhi High Court has ruled that Flipkart's latching on feature, which allows third-party sellers to list products under existing listings, cannot be used to sell fake products or mislead customers. Justice Mini Pushkarna was dealing with a copyright and trademark infringement suit filed against Flipkart by a furniture-selling brand, Maharaja. Latching on is the feature whereby an e-commerce platform permits third-party sellers to place a listing under an already listed product on the website. The More Sellers option on a product's page allows a user to see other traders of the same product. It was submitted that on account of the said latching on feature offered by Flipkart, other sellers who were not selling the genuine Maharaja products had latched on to the listings of the plaintiff. The court has observed that this feature cannot be used to deceive the public into buying products that appear to be from a trusted brand but are not. The court has ordered Flipkart to block unauthorized sellers from using the Maharaja brand listing and to extend its brand gating feature to protect companies' products. Flipkart has also been instructed to carefully review any sellers who attempt to sell Maharaja products and confirm with the brand if necessary. In the next update, the Kerala High Court has closed the anticipatory bail applications moved by film actor Jay Surya in connection with sexual abuse allegations made against him after publication of the Justice Hima Committee report. The crime was registered against him at Kottakulam police station in Ernakulam based on the complaint that the actor attempted to outrage complainant's modesty while acting in a film together between the years 2012 and 2013. The anticipatory bail application was moved apprehending arrest under IPC for the offences of sexual harassment and stalking. Another bail application apprehending arrest for the offence of sexual harassment was filed based on the complaint that the complainant was sexually harassed during a movie shooting held in the Kerala Secretariat. Justice C.S. Dias noted that the offences alleged against the actor are bailable offences since they were alleged to be committed before 2013. It was noted that Section 354 of the IPC was amended only in 2013 to make it non-bailable. It noted that the alleged offences were committed between the years 2008 and 2012 that is before 2013 amendment, and were thus bailable. And lastly, the students of National University of Juridical Sciences, Kolkata, from the batches of 2021, 2022, 2023 and 2024 have written to the Chief Justice of India, D.Y. Chandrachud, who serves as the Chancellor of the University, requesting the organization of a convocation ceremony for the 4 batches of LLB and LLM graduates. In the letter, the students have highlighted that the last convocation ceremony was held in October 2022 for the batches of 2019 and 2020 respectively. And since then, there have been no convocation ceremonies for the subsequent batches, causing great concern among them. The letter also highlights that other national law universities have been regularly conducting their convocation ceremonies, which further highlights the urgency of addressing the issue at NUJS. For more details on the cases mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Don't forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.